Once a trust is established and assets placed inside of it, does it have to be filed anywhere official or just maintained by the creator? In Florida, typically most trusts do not need to be registered or filed anywhere. They're a confidential document, so the contents of the trust between you and your trustee or trustees. And in most instances, you're able to keep it completely confidential. In fact, when you go to transfer assets into the trust, our office provides what's called a certificate of trust. It's sometimes called a certification of trust, which is a very watered down document that only provides certain information that was pulled from your trust, which would be needed by, say, a financial institution or maybe a property appraiser's office or another place where you're trying to transfer an asset out of your name and into the trust, because they are going to need some details in order to do that. Likewise, if you're buying a house, it's not uncommon to have to give the title company or your realtor the certificate of trust or certification of trust. And if this document is done properly, there's plenty of information in it that they need to use in order to make sure the asset is titled under your trust, or the trust is the owner. So there shouldn't be a need for them to see the entire trust. However, I do get this often where either a title company or a bank is requesting to see the entire trust because that's their protocol or what they normally do. But again, a well-drafted certificate of trust should obviate this need, and you should be able to just give that instead and not give your entire trust with all your distribution information and other information that you might not want everyone to see. Now, there are exceptions to this rule. There are times where a beneficiary could be upset about their inheritance under a trust, and it could result in a lawsuit. In that instance, the trust could become public record if it's the subject of an actual lawsuit. Also, beneficiaries, when they have a trust, could sometimes choose to disclose it. But really, the document itself, again, should just be between the creator of the trust and the trustee. The trustee obviously needs to know the contents of the trust because they have a very important role under the trust. But it can just be maintained by the creator in many instances. So I hope this answers your question. And if you have any other questions about trust, estate planning, asset protection, probate, and you're in Florida, please don't hesitate to contact our office. We're the non-stuffy attorneys at atCAUSE Law Office, and the link is in my bio.